Your Lordship's kind leave. Is that matter of 5%? Your Lordship related to my deposit 5%. My lord. There are some difficulties. We have already wrote a letter to the the assessing officer. My lord, I have mentioning this upon notice. If your Lordship take the matter on Monday or Tuesday, if they come with a proposal, Monday or Tuesday, my lord, if they come with an instruction, how we will pay? I will pay, my lord. I will get it.
Tuesday to be mentioned.
Tuesday.
My lord, may I be permitted to mention one matter? This is a Jalpaiguri, my lord, matter. The client is already here. He has traveled from Bihar to Calcutta. The bench is not available there. My lord, the goods are perishable in nature. These all are similar kind of matter. All related to Erica nuts and all vehicles have been stuck. We are ready to pay the penalty, my lord. But my lord, upon releasing the vehicle, my lord, leave be granted to file this matter before the principal bench and move before the
Why
principal
is
bench.
leave required? Leave is not required if the Jalpaiguri bench is not available. You can always file.
My lord, there is leave is required. My lord, I have taken instruction from the department. That is the reason, my lord.
আছে নাকি এরকম? যদি bench
That is the reason I have been moving this.
দরকার পড়ে না।
My lord, the department has instructed that this leave need to be required to file the matter before you.
যদি bench ওখানে না বসে নাকি এমনি ফাইল হয়ে যায়?
I yesterday only sought for instruction.
না
My lord.
থাকলে তো এমনি এখানে ফাইল হয়। হ্যাঁ এখানেই
Then allowed me to file that, my lord, kindly permit. With the similar kind of two matters. ঠিক আছে? ম্যাম নমস্তে বলছি। আপনি আমি জাস্ট
একটু ডিপার্টমেন্টের লোককে ডাকবেন কথা বলে হ্যাঁ তারপরে
much obliged, my lord.
16th of June, Honorable Justice Raja Basu Chaudhary had heard and restricted the DGGI to conduct proceedings only for 3 years. Whether that proceeding could have been conducted or not, an interim order was passed to the extent let DGGI continue the proceeding, but any outcome will abide by the result of the writ petition, and for further 3 years they were restricted not to conduct. Now for the 3 years the DGGI has conducted a proceeding and issued a show cause notice. Now department, we have intimated the department that the main writ is pending. The department has now issued second reminder notice to appear. The adjudicating
so the order you just now said has been the order says that it will abide by the result of the writ petition.
Lordship, liberty to Lordship, it says steps if any taken by the respondent number 2 shall abide by the result of this writ petition.
Yes, so there is no stay on further steps being taken.
No, Lordship. It was a case wherein there were parallel proceedings being conducted by
Whatever,
DGGI.
Lordship,
order... kindly take this order once, Lordship. Kindly. Now, Lordship, the adjudicating authority, which is not the DGGI, DGGI is already completed.
So if you are aggrieved by their further action and you feel that they are contemptuous, I mean the action is contemptuous, take steps.
Lordship, I have challenged that show cause notice separately in a writ petition.
Right,
also.
that's right. But
Lordship,
if you feel that they are acting in violation of an order,
no, Lordship, the jurisdiction of DGGI to conduct that proceeding is a challenge in this.
Maybe then in that case, if you win on the point of jurisdiction, entirety of this will go. But if you feel that there is a violation committed by them, then in that case you have your remedies open.
Lordship,
let us not argue at this stage.
No, I'm not arguing. Lordship, now they have given.
What has happened? You want this to be listed in the.
Lordship,
I will get it listed. It will be listed. But it will not get any precedence as an urgent.
My second writ is also challenging the show cause is coming in the list. It is running in the list.
Let it be taken up whenever it is.
Maybe your Lordship sleep. Yes. This is a hearing matter. Mr. Sharnal mentioned this before Lordship. This is an urgent hearing matter.
Hearing matter, please give this.
To mention this matter.
Hearing matter.
That is not urgency. You give it, it will appear. Can't be helped. Give it.
Lordship, motion. The urgency is that Lordship subsequent years refunds are getting adjusted and the issue is now squarely covered by Supreme Court is then Rajiv Bansal. The limitation period of surviving.
They appear as motion.
Grateful, Your Lordship.
Inclusion, please give the slips. Please give the slips. Don't mention. All matters for inclusion, please give the slips. They'll appear. List call.
The matter, my lord, has to be fixed for final hearing. But in the meantime, my lord, the division bench had restricted, my lord, the operation of the interim order till 15th of November. My lord, we would humbly request your lordship to extend the interim order and fix the matter for final hearing.
You are appearing for the respondents.
Respondent number 5, that is state.
My lord, I am for the enforcement directorate, respondent number 4, my lord.
For 10 to 20
So all the respondents are represented. There are several.
No, there should be 20. One was expired. There should be 20 respondents.
We served notice on all the respondents before mentioning the matter. All 20 respondents.
Who is the answering respondent? Who is the main respondent?
One of the main answering respondents would be the ED.
No, my lord, there are two answering respondents as per the interim order. One is enforcement directorate and other is media. My lord, the interim order was against enforcement directorate as well as media, my lord.
Who is appearing for the media?
No, my lord, there are
Media
several.
may be several.
There are several media
May be
houses.
several. Any one of the media is there?
Yes, I got appear for 6 and 7.
You are for 6 and 7.
Respondent number 18, your lordship.
18 is appearing, 6 and 7 are appearing.
I appear on behalf of respondent number 19, Twitter.
So 6, 7, 8 and 19.
I am for the Republic Media. It's 10 to 12.
So almost
all are represented.
all of them are. So I'm extending the interim order for a limited period and I'm fixing it for hearing on a date agreed between you all. Please tell me a date so that I can take it up for hearing.
My lord,
Any date, please give a suggested date.
I was wondering if it's convenient for your lordship to fix it, my lord, in the second week of December. That will give us
Some time.
My
some
lord,
time.
on 14, my lord, in this matter, I am led by learned DSG. He is not available on 14th and 15th of December, my lord.
14th, 15th. After 15th,
Okay.
he is available. Very well. लिखे नहीं?
After 15th.
The interim order granted earlier and which is to be in force till November 15, 2025 is extended till the end of December 2025, full stop. As agreed between the parties, list this writ petition for hearing on 16th, on December 16,
Grateful.
2025.
Lord, we had prepared an affidavit of service, but
Yes,
I,
sir, please give. Affidavit of service filed today be kept with the record ওটা উপরে লিখে দিন। আর সবার নামগুলো একটু প্লিজ লিখে নিন দিদি, কারণ অনেকগুলো আছে, প্রায় 15-20 খানা হবে নাম, সবার নাম লিখে নিন।
My lord, this is my application, my lord. On pursuant to lordship's direction, my lord, may be restored.
If you want to withdraw, you
My
have
lord,
to approve that.
this is a written instruction, my lord, kindly.
Yes. Learned advocate appearing for the petitioner. Hands up to court. Who is for the other side?
We are for the
You serve them again. None appears for the respondents.
Four, my lord, I am for the petitioner, my lord. Lordship. Petitioner is the, my lord, co-owner.
Please, let me
Petitioner is the co-owner of the plots in land, my lord. And private respondent also co-owner, my lord. Private respondent is filling the pond, water body, my lord. And to that effect, I have made representation before the DM, my lord. And let DM be considered the representation, my lord.
Who is appearing for the state?
I have served, lord.
You are appearing for the private respondent.
Private respondent, my lord.
So let the district magistrate consider the
Lord.
representation upon hearing you.
Lord.
He will hear you also. He will hear you also. He has made a representation. Why should this not be considered?
Lordship, may I place the provision, my lord? Section.
Other occasion, I make a very elaborate submission that regarding the maintainability of the writ petition.
What maintainability? If he has made a representation, it should not be considered.
Entire
Please answer the query of the court. Don't go into long drawn arguments. Whether this, if a representation is made, whether that should be considered or not.
Court, the case is already pending before the civil court. An injunction order is there. By suppressing the material fact of the case, they appear before this honorable court. Without
Fact of filling up of water body is there before the civil court.
No, my lord. No, my lord. No, my lord.
How?
Yes, there.
That can.
And
Filling up of water body is within the
Provision is there, my lord.
this honorable court.
Show me.
And my lord is once I produce a document before the honorable court.
Bar to conversion is there, my lord. 17A, lordship.
Regarding this global.
Please show me the document.
Number of document I have with you. Your lordship, allow me to file the opposition.
No opposition is required.
That will unfold the entire picture.
Where is the identity model of injunction? Yes.
And the next date is January 2026. Because there is no spelling in the writ petition.
Yes, sir. Why have you not mentioned this in the writ petition?
Lordship, my only grievance is this, my lord, filling up the pond, my lord. Nothing else, my lord. My prayer, let the section 17A be complied
with
with.
respect to the pond itself, this suit was pending. Why have you not filed the
Lordship, suit is pending regarding ownership, my lord. But here,
but the pond is involved in that or not?
Lordship, I have to take instruction regarding this, my lord.
Instruction, come back.
Lordship, my only submission is this, my lord.
If this is suppression, I will dismiss it. Learned advocate appearing for the petitioner. Learned advocate appearing for the respondent submits that this writ petition suffers none appears for the petitioner. Full stop. The petition. My lord, due to some medical emergency in her home, my lord, she requested not today, my lord. Can we keep him at tomorrow? Under the same heading, my lord, can be heard. An adjournment is prayed for.
It is shown as outstanding it has not been received. Now, in the assessment, in course of the assessment proceedings, towards the end of the letter was submitted by the petitioner to buy peace, and if it was opportunity was afforded to get immunity from penalty, a sum of 13.5 crores was offered on that condition, and without making any admission. It was just to, some of that letter was submitted. The assessment which was framed, but in that assessment, out of the jewelry of 14.14 crores, he accepted the explanation in respect of 1.66 crore. So that left us with about 12.3 crores. Now, with regard to 12.3 crores, when my lord has a look at the assessment order, there's no discussion about the source, the explanation which I had offered, which was backed by evidence, affidavits, documents. There's no consideration of that item by item in the assessment order. Just the part that he has accepted, he has said, I accept 1.66, the rest. Out of the cash note, he accepted for about 50 lakhs, so 1.98 out of the cash and 12.33 out of the jewelry and bullion. So it aggregates to 14.31. So he telescoped this 13.5 crores which was offered. He reduced that 13.5 crores from 14.31 and separately added 81 lakhs 34,000. So he added 13.5 crores which I had offered, and he added another 81 lakhs in the under section 69A.
So the 13.5 crore which you had offered was applied to the jewelry, saying
Yes.
that it has been used to procure the jewelry.
Yes, so the telescoping was done. So so this was the assessment. The 13.5 crores plus 81 lakhs was added. Now against the assessment, an appeal was preferred because the assessee's explanation with regard to the jewelry, the 12.33 which was added, that explanation had not been looked into. So that was one of the grounds of appeal. Then this 13.5 crores addition with the penalty proceedings that was there, so that again was put in challenge. So that matter is in appeal. It's before the commissioner appeals. Now the commissioner, the administrative commissioner, acting under section 263, he issued a notice saying that the this 13.5 crores was actually the firm's income, and it should have been added in the firm's hand and not in my hands, because this is professional receipts which the firm had collected, although shown as outstanding, but it should have been added in the hands of the firm and not in my hands, and that the officer should not have done this telescoping, because this is the money is of the firm, then in the hands of the individual. And he said that in course of the assessment, the source of the gold and bullion, the jewelry and bullion, had not been examined, which was my grievance also before the Commissioner Appeals, because the officer had not really, the audit does not reflect that examination. Commissioner also faults the officer for that same, on the same point, that he has not examined the source. So we are, now the question is also whether under section 263 he has the power, because once the matter is before the Commissioner Appeals, whether the Commissioner...
Entirety of it is at large before him.
Lordship. So at least as far as this is concerned, that source of the jewelry and bullion, that source is a question in appeal, and he's also not raising that as an issue in the 263 notice. Those proceedings are pending. So that's how things were. But suddenly, in October, 24th October, they issue a letter, the assessing officer issues a letter saying, I want to carry out inspection of the jewelry. Now, the jewelry, according to the chain of custody, it is resting in the strong room. I shall place the provision of the rules. If it has to be open, it has to be for a purpose of the act, for the purposes of the act. So initially a letter was written, because the assessee has, he's obese and he has got many medical issues. So he given a letter on those lines. And then they again refixed it. So then again he requested that please wait. And then he, on the same day, he gave a detailed letter contesting it. They said that you do not have the power to do this. The assessing officer has become functus officio. This is the entire inventory. They had a good look at the jewelry and bullion. The entire exercise was done at the time of search. The lists have been prepared. The details are available. So therefore, the assessing officer cannot just ask for inspection, and the chain of custody is going to be disturbed, valuables are going to be unnecessarily handled. So it has to be for the purpose of the act. You have not indicated any purpose of the act. Why should this be disturbed at this time? So then they've written a reply and response, and the response says, generally refers to the pendency of the 263 proceeding, which I myself had mentioned, and says the commissioner there has powers to direct any inquiry which he deems fit. Although I shall show from the notice that the inspection of the jewelry is not an issue, because that the commissioner says the source was not looked into, and which is my grievance in the appeal. So after generally referring to the power of the commissioner under section 263, then they say we have some information. Now, what information? That is not mentioned. Now, where there is a search, the element of surprise is when the search happens. Now, the parties are litigating. So, without showing a purpose of the act, the assessing officer cannot take it upon himself to just disturb the chain of custody and not unnecessarily handle valuables based on some unknown information. I cannot be taken by surprise, because the
assessing officer otherwise has power to go on for an inspection.
No, I shall just show the rule. But first, if my lord is pleased, section 132, subsection 9A, which says but section 132 is the section for the search and seizure. Kindly see subsection 9A.
9A.
Where the authorized officer has no jurisdiction over the person referred to in clause A or clause B or clause C of subsection 1, the books of account or other documents or any money, bullion, jewelry or other valuable article or thing hereafter in this section and in sections 132 and 132 be referred to as the assets seized under that subsection shall be handed over by the authorized officer to the assessing officer having jurisdiction over such person within a period of 60 days from the date on which the last of the authorizations for the search was executed, and thereupon the powers exercisable by the authorized officer under subsection 8 or subsection 9 shall be exercisable by such assessing officer. So this is the handing over part. Now we'll kindly take the rule. But I have made photocopy if it. But the rule starts at page 2,
yes.
And we'll kindly take note at page 6. But sub-rule 10.
Sub-rule 10. Yes.
May I place it? The authorized officer shall place or cause to be placed the bullion, jewelry, and other valuable articles and things seized during the search in a package or packages, which shall be listed with details of the bullion, jewelry, and other valuable articles and things placed therein. Every such package shall bear an identification mark and the seal of the authorized officer or any other income tax authority, not below the rank of income tax officer, and the occupant of the building, place, vessel, vehicle, or aircraft, including the person in charge of such vessel, vehicle, or aircraft searched, or any other person in his behalf, shall also be permitted to place his seal on them. A copy of the list prepared shall be delivered to such occupant or person. A copy shall be forwarded to the Chief Commissioner or Commissioner, and where the authorization has been issued for any by any officer other than the Chief Commissioner or Commissioner, also to that officer. So, the detailed procedure, seals, etc. Now, kindly take the next page, 11. The authorized officer may convey the books of account and other documents, if any, seized by him in the course of the search made by him, and the package or packages, if any, referred to in sub-rule 10, to the office of any income tax authority.
Will be handed over to the custodian.
Yes, ma'am. Now, kindly then take note 13. Whenever any sealed package is required to be opened for any purposes of the Act. So this is what the guideline is available. For any purposes of the Act, the authorized officer may, unless he is himself the custodian, requisition the same from the custodian, and on receipt of the requisition, such package or packages as the case may be, shall be delivered to him by the custodian. The authorized officer may break any seal and open such package in the presence of two respectable witnesses after giving a reasonable notice to the person from whose custody the contents were seized to be present. Such person shall be permitted to be present till all or any of the contents of such package or packages are placed in a fresh package or packages and sealed in the manner specified in sub-rule 1 or delivered to such person or the custodian as the case may be. So, but it must be not for the purposes of the Act. Now, because once the chain of custody gets disturbed, the entire seizure which is made, these are valuable items, and so that entire thing gets disturbed. Therefore, must be for the purposes of the Act. Now, kindly see the communication. If I may just show that purpose, in my humble submission, they are not forthcoming. But kindly take the first. But kindly take page 378.
Yes.
Now, this is the letter from the assessing officer, 24th October. Subject matter is fixation of inspection of gold jewelry and gold bars.
Didi, একটা flag দিন না। Yes, sir.
During search and seizure action under section 132 of the Act conducted on 21st June 2022 and on subsequent dates. It is to inform you that inspection of jewelry and gold bars as tabulated below seized from your premises lockers during the course of search and seizure action on 21st June and on subsequent dates has been scheduled to be on 29th October at the strong room. And they list the locker details and the place of recovery. In this connection, you are requested to be present personally or through authorized person at strong room. So just a direction for inspection. Not that I have to be there. They are going to do it. But
why inspection is sought for?
No, nothing. Number that adjournment request. Kindly. It's not necessary for me to trouble my lord with. Kindly now take note the letter which I had written, but kindly see the answer. The letter which I had written is at page 385, which is the detailed one, and I had if my lord is pleased to have at page 385.
385.
Yes, ma'am. This is my letter of 4th November.
Yes.
Paragraphs 2, 3, 4, I need not place note. Paragraph 5, I mentioned what happened in the assessment. Paragraph 6, appeal is pending. Number 7, the issue, source, ownership of seized jewelry mapping to owners, their explanation and addition under section 69A now stands in appeal before Commissioner of Income Tax Appeals. Explanation 1C to section 263 bars Principal Commissioner from revision whether issues subject matter of appeal. It underscores that no one, including the AO, can act outside the appellate channel on an issue subject matter of appeal. Here, the AO has already exercised jurisdiction, culminating the assessment order dated 30th March 2024. Departmental valuation reports 11 in number, and the assessor's itemized reconciliation with evidence were already on record before the assessment was made. Then the reference is made to rule sub-rule 13 of 112. Then the last line of paragraph 8. I have to state that no purpose of the Act has been or can be indicated in the notices dated 24th October and 29th October, which requires the sealed packages to be opened by breaking the seals thereon. The notice discloses no statutory basis and no specific purpose. It is not tied to any proceedings pending before the AO. Reopening sealed packets for inspection after more than 38 months long custody without clear authority risks chain of custody disputes and needless handling of valuables already valued, sealed and deposited as per procedure. Then what they had said in the notice that, well, if you can't come, then your authorized representative can be there. So then the next paragraph says that my authorized representative will have no knowledge of these things. With the jewelry, those are personal things, or there are so many other claimants. The assessing officer accepted 1.66 belongs to other people. For the most part, I am saying it belongs to the father-in-law. So an authorized representative cannot be at the inspection of the jewelry. He cannot achieve anything. He will not know enough to be of any assistance there. So that part is dealt with in the next paragraph. Then in paragraph 11, notice dated 29th October, refixing inspection on 4th November in the strong room in respect of jewelry, bullion seized so-and-so without jurisdiction and bad in law because they cite no purpose of the act, are not referable to any pending proceeding before the assessing officer, seek to revisit assets already inventoried and valued per departmental procedure, and risk chain of custody disputes and needless handling of valuables already valued, sealed, and deposited as per procedure. So these were the different points. Now the answer is the next page, page 387. Paragraph 3. The objections raised by you by email dated 4th November are addressed as follows. Proceedings under Section 263 of the Income Tax Act has been initiated for the erroneousness of the assessment insofar it was prejudicial to the interest of revenue, which is quite independent of subject matter of appeal. The PCIT is competent to make or cause to be made any inquiry as it deemed necessary before passing an order under Section 263 of the Income Tax Act. It has also been stated by you that the notice discloses no statutory basis and no specific purpose. The statutory basis has already been mentioned in the preceding paragraphs. As for the purpose of the inspection of seized assets, suffice it to say the department is in possession of certain information of which has to inspect the seized assets kept in the strong room. It is also stated that this exercise is relevant and useful for the purposes of the Income Tax Act.
So apparently it appears that this is done for the purpose of 263 only.
Now, that part, if I can show the proceedings which have been initiated for 260, and then they speak of this information which is
because this is a preceding paragraph.
Lordship. Now, kindly see the notice under section 263. Volume, kindly take volume 3 at page 355.
Page 355.
My lord. It recites the search part, and then we'll kindly take at page 356, paragraph 5. The assessment record was called for, examining the correctness of assessment order. It is gathered on perusal of assessment record that certain transactions issues were not properly examined, verified by the AO during the course of assessment. Then paragraph 6, during the assessment proceedings, you were requested to reconcile the cash amounting to 2 crore 48 lakhs and jewelry and bullions worth 14 crores that was seized during search and seizure action at your residential premises, as well as in various lockers held in the name of yours and your family members. In his submissions made during the assessment proceeding, you tried to reconcile the above-mentioned seized cash and seized jewelry and bullion. However, the same could not be satisfactorily reconciled, explained in view of the discussions below. Then he goes into that part. It is his view on my explanation in course of the assessment proceedings. Then kindly take the where he criticizes the assessing officer. Kindly have at page 364. Paragraph 17.
Yes.
In the assessment order passed for assessment year 23-24, AO has erroneously accepted the additional income of 13.5 crores offered by you in your hands on account of the above said allegation of undisclosed professional income from DJ Shah and Company on account of undisclosed debtors, which should have been assessed in the hands of the firm DJ Shah and Company as per discussion under para 9 above. The AO further, while framing the assessment order, has wrongly considered the jewelry found and seized in your case as the application of the said undisclosed professional receipt, which makes the assessment order erroneous, as the said undisclosed professional receipt pertains to the firm DJ Shah and Company and not you. Then, it is evident from the above that the professional receipt of 12 crore 85 on account of debtors which remained undisclosed unaccounted was requested to be considered in the hands of the firm DJ Shah and Company. However, the same has been considered in your hands, who is the partner of the firm, in your assessment order passed for the assessment at 23-24, wherein it was stated that jewelry and bullion found at your premises were sourced from the above stated undisclosed professional income. In view of the above facts and circumstances, the assessment order in the instant case becomes erroneous, as the undisclosed professional income of the firm DJ Shah and Company was assessed wrongly in the hands of its partner Miraj D. Shah for assessment at 23-24, in whose case gold, jewelry and bullions were seized, which was stated to have been sourced from the application of the above discussed undisclosed unaccounted professional income on account of debtors. Further, the assessment order is prejudicial to the interests of the revenue, as certain income which ought to have been taxed in the hands of the firm was taxed in the hands of the partner of the firm, and corresponding benefit was given to the partner by accepting the source of the assets in the form of jewelry and bullion found and seized from his premises as the application of such undisclosed professional income of the firm. Further, the source of such assets in the form of jewelry and bullion were not verified, inquired during the assessment proceeding, and thus the same remained unexplained. Explanation 2 to section 263 of the Act envisages that, for the purpose of this section, it is hereby declared that an order passed by the assessing officer shall be deemed to be erroneous insofar as it is prejudicial to the interests of the revenue. The order is passed without making inquiries or verification which should have been made. The order is passed allowing any relief without inquiring into the claim. The order has not been made in accordance with any order, direction, or instruction issued by the board under section 119. In the instant case, the assessment order was passed without inquiring, verifying the issue of source of asset in the form of jewelry and bullion pertaining to the assessee, as discussed supra, which makes the assessment order erroneous insofar as it is prejudicial to the interests of the revenue within the meaning of section 263. The last paragraph is also significant. In view of this, you are requested to show cause on 17th March as to why the order passed by the AO in your case dated 30th March for the assessment year 21-22 should not be revised under section 263. In case of non-attendance, failure to submit the reply, the undersigned should be constrained to proceed with the matter based on the information available on record in the light of the observation made above. So what the jewelry, the bullion, they were all looked at, inventoried at the time of search. The commissioner does not fault that at all. The commissioner does not bring in that aspect which is now being for which the inspection part, that there's anything wrong with the inspection, that something was not done. He is not saying. He said no, that money should have been taxed in the hands of the firm. That money could not have been used to acquire this, because that is the firm's money. So it could not have been, should not have been telescoped against this, these particular assets, and the source of the those assets was not looked at. That is my complaint in the appeal also, that I have given the entire explanation with evidence, and that has not been looked at. So there is the commonality, the subject matter of the appeal and the subject matter of 260. So I have taken that point, but this notice does not reflect that there is
any inquiry required as regards the valuation of the
so normally kindly see the kind of exercise which was just to give a glimpse of how it was done. If my lord is pleased to have volume 1.
Yes.
But page 77, there are 11 valuation reports. I shall draw attention to just one. Because page 77 is the Panchnama. In respect of locker number, it's mentioned locker number so and so, such and such bank, and then look at page 78. The following were found and seized. Bottom half of the page. And II, jewelry, ornaments, bullion, gold bars, etc., which have been inventorized as per Annexure J. Jewelry items numbers S1 to S3 valued at 9.91 crore have been seized. But this document is at page 121. I'm sorry, 121 is the end. It starts at 117.
Yes.
Manoj, this is the person who has done it. Manoj, is a government-approved valuer and consultant of precious stones. So, Manoj, the valuers, the department gets their own valuer. Report of valuation of the jewelry. Manoj, the address is Federal Bank. Manoj, that locker number is mentioned, and Manoj, the serial number is there. Description, gross weight, approximate net weight, metal description, making, metal value, stone description, approximate weight of stone, stone value, total value. So these are the different details which are noted. But this goes on up to page 121, S1 to S33. And the total struck at the end of page 121 is that 9 crore 91, which is the figure mentioned in that Panchnama. And the different people would have signed on this document, the witnesses to the search, the authorized officer, the assessee spouse, the valuers, they have all not. This an elaborate exercise, because the valuer will look at everything, and the officers were also there, the income tax department officers, they were also involved. So they've had a good look at everything, even tabulated. Now, to disturb this, but there must be a good purpose of the act. Otherwise, I cannot see it being related to the 263 proceedings, because the commissioner is on a legal footing, and a legal come factual footing, where he says who should have been assessed, to whom should the source have been attributed as far as this is concerned. He's faulting the assessing officer on that, but nothing to suddenly to start this exercise. There must be purpose of the act. They have to satisfy the court, and I cannot be taken by surprise here. Because if there is a purpose of the act, then I will prepare accordingly. If I need to take my value, there are other people to whom the things belong. The chain of custody is going to be disturbed. So it is rather strange that they are in such haste. They've had it all. I'm already in their hands. I'm not going away anywhere.
Yes, Mr. Dhuria, what is the purpose? Why have you not mentioned the purpose?
There's certain some confidential report which cannot be disclosed in open court. If your lordship says, I'll produce silk cover. We have received some report, confidential, on the basis of which the inquiry was being conducted. I have a specific instruction to that. And this is inspector of section 263 proceedings going on. It is so confidential, I cannot tell in the open court. This is my specific instruction. If your lordship so desires, I'll place those report to your lordship, which cannot be shared to them. I have a specific instruction to refer. But here, 263 proceedings are separate proceedings, and lordship, if your lordship will
but
kindly.
263 proceedings have not questioned the valuation. 263 proceedings have only questioned the source.
Yes.
So whatever may be the value, from where has, from what source has the jewelry been procured, is the only subject matter of 263 proceedings, not the value of the item.
But
If
if your
the
lordship,
value of the item is 1, it is
yes,
1.
yes,
But from where this 1 has been procured
Yes.
is the subject matter of inquiry.
yes, yes, yes.
Not whether it is 1 or whether it is 0.75. That is not the subject matter of inquiry.
But my lord, if your
So
lordship,
in this context, how is this 260?
but lordship will kindly section. Lordship will kindly have a look at section 260. Lord. I'm just placing it for my own satisfaction, Lord. Lordship will kindly have a look.
263.
But yes, but my point is that how he is prejudiced. It's an inquiry. It's not about there's no charge has been framed. It's just a question about inquiry. He has to participate, and it is not that the section rule says specifically on the witnesses will be there. Everybody will be there on their presence. Everything will be done. It's not that it's just an inquiry process. No charge has been framed. This is also one more submission. Lordship will kindly say section 2 revisional orders prejudicial to the principal, chief commissioner, or commissioner such and such commissioner may call for and examine the records of any of the proceedings under this act, and if he considers that the order passed therein by the assessing officer or the transferring pricing officer is erroneous so far as the prejudicial to the interest of the revenue, he may, after giving assessee an opportunity of being heard and after causing to be make inquiry, this is deemed pass such orders. It means that he may call for examine any records in these proceedings. Lordship will kindly the
But this is not record.
Anything. It's not record, but any. For the purpose of examination, I'm placing. Lordship will following the order enhancing modifying. Straight away, if your lordship will kindly come to the explanation 2, for the purpose explanation 2, for the purpose of this section, it is hereby declared that the order passed by the assessing officer or the transfer pricing officer shall be deemed to be the erroneous so far as prejudicial of interest of revenue. If the opinion of the commissioner or the commissioners, the order is passed without making inquiries or verification which should have been made. And my lord, order is passed allowing any relief without inquiring into the claim. The order has been passed in accordance with the order. Direction instruction has not been passed in accordance. So orders is passed without making inquiries and verification. This is the stage of inquiry. If your lordship will kindly sees, my lord, the 263.
Mr. Dudhoria, the inquiry must be relevant to the question posed.
Yes.
The question posed is what is the source? How
Yes.
is this inquiry relevant as to what will be the purpose served by inspecting the jewelry? By inspecting the jewelry, source of procurement of jewelry will not be able to be established.
Mala.
Source of procurement of jewelry is the fund utilizing which the jewelry has been obtained.
Mala.
That is the scope of inquiry.
Mala.
But inspection of the jewelry does not seem to be a relevant inquiry for the question, for answering the question that has been posed in 263.
But what I'm humbly submitting, certain things were seized, sealed packet in a sealed packet, I understand your lordship says the source is the only thing, the
Yes,
valuation
because
is not a
that is what the if you see your 263 notice.
Yes, lordship will kindly have a look at 355. My lord, may I just place
355. Kindly see the penultimate paragraph.
No, lordship will
see the penultimate paragraph, paragraph 20.
Paragraph 20. But before that, paragraph 19 also.
Paragraph 19, he has quoted the section and
also regarding the jewelry, he has specifically stated.
Yes, he has said, but he has said about the jewelry in paragraph 20 also.
Yes.
But how does he relate the jewelry to the source is only thing which is coming out. Kindly read paragraph 20.
Yes. Paragraph 20.
In the instant case,
the assessment order was passed without inquiring, verifying the issue of the
source of assets, not the valuation of the
source of the jewelry bullion pertaining to the assessee, as discussed supra. But the preceding paragraph, he has said about this that regarding the valuation.
Where so?
In view of the above circumstances, orders passed in instant case, the erroneous superficial interest of the assessee wrongly in the hands of the partners, in whose case gold and jewelry bullions were seized, which were stated to have been sourced from the applications of the
so relating to source.
Relating to source, and also it says that in whose the case the gold and jewelry has been seized. I understand it's related to source, but Further, the
But how
assessment-
is this then relevant? Why is this inspection is necessary? What will happen by inspecting the jewelry? You will not be able to make out the source. Inspection of jewelry will lead you to the valuation. That is the most that you can do by inspecting the jewelry.
Yes,
Nothing,
yes, yes,
nothing
yes.
further
But what
than
I
that.
yes, yes. That can also be the what I'm humbly submitting. I don't
Then
know.
what is the purpose?
I-
That has to be.
Milord-
It has to be for a stated purpose. It
Yes,
can't
yes.
be for an undisclosed purpose.
There are certain. I'm telling you the exact. The purpose is that the jewelry which is there. I don't. Although it's a confidential. That statement has to be come from them. Whether the jewelry is the valuation has been properly done or not. Whether the jewelry is.
But
which
that is
there,
not the question.
which is there, that is whether the valuation has been not done on properly or not, and also whether on that ground this has been done.
You come with a report stating the clear purpose.
Yes,
Today
yes,
you
my lord,
don't
in a
do the-
confidential.
You don't go for inspection today then.
My lord, I'll file a report, my lord.
Yes.
An order may pass to that effect, my lord.
Yes, of
Yes,
course.
yes, I'm
It
grateful.
has to be an order.
I'm grateful, sir.
You will postpone this exercise
My lord.
till
Next
a
date, my
date
lord.
after the date when the writ is fixed for hearing.
Yes, yes, yes.
The writ petitioner appeals.
But your
Lordship,
lordship,
communicate.
Your
এটা
lordship,
ওখানে একটা লিখে দিন।
but since it's a confidential document, may I in a seal cover, may I report in the form of an
Report in the form of affidavit.
affidavit, my lord.
Yes.
My lord, my instruction is first note, it cannot be at this moment, can't be that can be this report can.
You file the report in the form of in the sealed cover. We'll see that. Don't bring your confidential document
My lord.
if you don't want to disclose.
My lord. That's why I'm saying that if it's in a seal cover report, will next date will produce a
Very
report.
well, in the form of affidavit না করে report করে দিন।
Report. I will only produce the
You
report
bring a report.
thereafter.
Very well, you
One
bring a
thing.
report in a sealed cover.
My lord.
Report in a sealed cover করে দিন।
My lord.
আর ওখানে যেখানে ওই লিখেছেন না যে কাস্টাডিতে আছে, ওখানে একটা লাইন আরো অ্যাড করে দিন যে
Item 8, before Lordship takes up other matters, we had a joint discussion, Mr. Kundali and myself. Lordship may recollect, this is the matter
yes,
where
yes,
clubbing.
bunching,
Yes,
bunching.
yes, my lord. Now, I had one of the issue, my lord, section 61, but what we have agreed by amongst ourselves, let it be postponed to another day, the hearing, postponed to another day, and the arrangement which is there, that may continue till that day. There is an
When is the date? Next date?
Your Lordship has indicated that a date may be fixed like this matter later.
So it won't be affected. If in case you will get a notice definitely. You mention it, I'll extend it.
That will not be a difference. No, my lord, the date is fixed tomorrow. No. I mean, oh, then
At this time.
Yes, yes. My lord, 27th, man. 27th.
Before that, if the date comes, you please mention.
Yes, yes.
I'm not passing any order. এটাকে 27 তারিখে লিস্টে দেবেন।
Yes.
8 নম্বরটা হ্যাঁ না আজকে আর কল করবেন না, ওইগুলো শেষ হলে 9 থেকে কল করবেন।
Take some time. This will take some time, which is why. Great.
I am for the petition. It relates to unauthorized occupancy of government land. Last occasion, my lord,
Respondent represented.
My lord,
Respondent.
respondents was there. My last occasion, my lord Justice Biswajit Basu was pleased to direct me to add party to Jila Parishad and serve a copy. I have done it. My lord, it's required to direct the SDO to hear the matter, and if it is the government land.
You serve a notice. Nobody is appearing.
My lord,
Then I will not take. You serve a notice.
my lord, it's little.
Serve a further notice.
My lord, SDO will
Nobody is
hear.
appearing for the state also today.
My lord, SDO will hear and give the notice.
Very well, but they should be here. Serve a
My lord,
notice.
if it is government land.
Serve upon the government leader's office. They will ensure representation. You serve upon the parties. That is why they don't appear. You serve on the government leader's office. They'll appear. None appears for the respondents. Full stop. The petitioner shall
But on the last occasion, I have indicated to your lordship that affidavit opposition and reply have completed.
Yes.
Now, my lord, the matter is that the petitioner before your lordship is a tenant under the Shama Prasad Mukherjee Port Trust. Monthly tenant. He was carrying on business.
Just a minute. দিদি ওই আগের ম্যাটারে এটা রয়ে গেছে ওই যেটা ইনকাম ট্যাক্সের ম্যাটারটা আপনি একটু ঢুকিয়ে দিন ইয়েস
He was carrying on business. Now, my lord, from 1992, no rate bill was issued. Time and again, the office of the authority was approached by my client. The written documents are there, but not this is not now available. I cannot produce your lordship any written document. What written document we have requested them for issuance of the bill for payment of the dues? Nothing. Now, my lord, all on a sudden, the next step they have issued one caveat notice, caveat that such and such matter, don't move anything before any other court without giving any notice. But no document, no order, nothing has been sent. Only the caveat notice. Your lordship, kindly come to page 18 of the writ petition. The caveat has been sent to us long back in February 2022.
Page 18 of the writ petition.
Yes.
Yes.
They have given the number of the case and the order date, but nothing has been communicated to us relating to the order or any other thing. So that as per the procedure under section 9 of the act, we can prefer the appeal or any other thing. Nothing has been done. Subsequently, your lordship, kindly come to page 20 and 21. 20. They have issued this notice to us on the fresh copy is next page, I believe. No, on in December, 6th December or 7th December, like this, regarding due. Your lordship, can you see 9,58,270.02 being the area rent and taxes up to 31st October 08, 2024. Immediately on receipt of the same, my authorized representative put the amount in different installment from page 22 onwards. Now, the check has been deposited to them. This is the amount. Then this amount was next page. From 22 page 22 onwards. This is the bank receipt. First, 3 lakhs have been given. Then 50,000, page 25. Then again 50,000, page 26. Then page 27, 50,000. Page 28, 50,000. Page 29, another 50,000. After payment of this, your lordship, kindly see, this is the dated 10th June 2025. This is the amount they have received 10th June 2025 from Dial Automobiles, my authorized agent. I have disclosed that he is my authorized agent. He has deposited that amount. Now, that person, after depositing the same, all on a sudden they have come, page 30. They have taken over the possession on the basis of the eviction order. And they said that the eviction order is 2nd February 2022. There are two questions. When I moved this writ petition, I moved two questions. I placed two questions. If it is the eviction order 2/2/2022, then 2/2/2022, whatever dues are there, they are. For that, the eviction has been made. If I take it in that manner, then, my lord, this page 22, sorry, 21, 20 is redundant because they have said area rent and taxes up to 31/8/2024.
No, but in the last paragraph, they say that this will be taken to be payment as compensation for wrongful use and occupation.
No, no, no. This is to note that any payment made by you on behalf of received on behalf of an account of the
on
aforesaid
account of
outstanding
aforesaid
dues
account
will be
dues,
deemed
yes.
to have been tendered by you as compensation for wrongful use and occupation and acceptance. Then, my lord, this is for damages, not for area rent or any other thing.
Yes, that is what they have clarified. That it may have been for arrear rent, but this I am accepting
Now,
as damage.
now, on this, my lord Justice Basu was pleased to direct them to file a report in the form of affidavit. In the report, they have disclosed many things. Now, your lordship, kindly allow me to place that report.
Yes.
Because I have to made out my case from their report itself. Because they did not communicate, they did not serve anything to me. Now, your lordship, kindly come to the report, first page, page 8.
Yes.
This is alleged to have been the notice issued under certificate of posting, then registered with acknowledgement. I don't know what is this. Then what is this? I hereby give you notice to quit the premises described hereunder or that portion of the said premises now occupied by you in respect of which you are tenant of the trustees on the expiry of the month of June 1992 or at the end of the month of your tenancy will expire next after the end of 1 month from the date of service of this notice, failing which trustee will be compelled to take steps for eviction after the due compliance with the process as provided in law. Now, here they have given the description of land, but in the notice itself, why the notice of quit is given for non-payment of the dues for which how many period? Nothing. No description. Your lordship, can you see? Your lordship has seen appearing in this side just few months back, appearing on behalf of the state government undertaking and the central government undertaking. Your lordship has enough experience on seeing this, even for the bank. That the notice for quit or notice for anything give the specific description. Why the notice of quit is being sent? What is the amount due and payable? Nothing. It's absolutely vague in nature. Next. Now, this is the tenancy is in the name of Pankaj Kumar Chakraborty. Your lordship, kindly again come to page 8.
Yes.
This is issued in favor of Pankaj Kumar Chakraborty and Pradeep Kumar
Pradeep
Chakraborty.
and sons of Purimal Ananda Chakraborty.
He was my father. After his death, this has been assigned to me. Pradeep Chakraborty is nobody in this plot or nobody in this business.
8 and 9 are same.
Number 9, yes, 8 and 9 is the same.
Yes.
Then you also can come to page 10.
Pradeep Chakraborty.
It has been sent to Pradeep Chakraborty, who is not the tenant in respect of the premises. Now you will also kindly come to here. Some endorsement is there, but I cannot read this endorsement. Page 11. Intimation sent, 1. Then
one is not available on duty or something.
the notice was served not on me but to others. My brother is a separate identity, not me. Next, your lordship can see page 12 also. Acknowledgement, Pradeep Kumar Chakraborty. Then your lordship kindly come to page 14. Now, my lord, this is the notice dated 13/5/1992.
Page 14.
Page 14. No, this is something else. Initially, the notice was page 8 and 9, 13th May 1992, notice to quit. Now, this is their interdepartmental memo. They have disclosed in their affidavit. What is the memo? The land officer, assistant land manager on 26/4/1993
Seeks eviction.
wrote to the estate officer on 31/5/1993.
Payment of arrears is what they want here.
Now, my lord, this is not served to me. This is not a service on me. This is their interdepartmental memo. Had it been a case that this has been served to me, you pay it, otherwise the eviction notice will effective. Nothing. This is their interdepartmental memo. I don't know what is their claim, whether they have issued the bill or not. According to my instruction, up to 1992, everything we have paid. Whatever bill there is. If there is something due, very well, I am not disputing. This is their interdepartmental memo. Nothing has been informed to me. Next page, your lordship, can is more interesting. My lord, this is of 13th May 1992. Now, my lord, next page, page 16, is 10th September 2021. After long 29 years.
Yes.
Now, your lordship, kindly see what is there, the statement of the opposite party. That means Port Trust. It is submitted that OP came to the occupation, not opposite party petitioner. OP has came to the occupation of the Port Trust, port property in question as a monthly lessee. He is in default in making payment of monthly charges in clear violation of terms and conditions of the lease in question. How many months? Nothing. Accordingly, quit notice issued on 13/5/1992, asking OP to vacate the premises on the expiry of the month of June 1992. It has never served on me. Question of asking me does not arise. So, my entire proceedings drawn on this. Now, my next page, your lordship, kindly see. Yes, page 17, last paragraph. Sri P. Chatterjee on examination states that OP was allowed to enjoy the property in question on monthly lease, and OP has been enjoying public premises in question wrongfully. Heard the submission and considered the matter on the basis of the materials on record. After careful consideration of the submission made on behalf of SMPK and materials produced before me, I find that SMPK has made a strong privacy case for formation of my opinion to proceed against OP under relevant provisions of public premises eviction unauthorized. Last portion has not been typed out. Let a notice under section 4 of the Act be issued to OP for production of the documents, evidence and hearing on 28/9/2021 at 4 p.m. All points are left open for discussion on merits of the case on the basis of the show cause notice under section 4. Now, our next portion is regarding section 7. Let me place also section 7. Now we must give a meaning of the term unauthorized occupation as per definition provided in the PP Act itself. At this stage, for the purpose of adjudication of SMPK claim for damages only under SMPK's application dated 31/5/1993, which may have arisen due to unauthorized use and occupation of the public premises in question after expiry of the period as mentioned in the notice to quit, I find no bar to assess the damage as per rules made under the Act. I have examined the representative of SMPK and find that charges as claimed by SMPK on account of damages against OP are equivalent to the amount that has been claimed.
Yes, yes, I have read it.
Now, my dear lordship, the last page. Notice has to be served upon the OP through registered post with AD. Application on the property OP and to file reply to so-called notice 28/9/2027. Next 2 pages
Notice. This is
are the notice, the section
Form
4
notice and form
notice,
3. Yes.
and then section 7 notice.
Yes.
These are 2 notices, but there is no document whether it has been served or
No,
not.
no, it has not been served. Next page, page 22. I have just now read.
Page 20, you will see through speed post as recorded, address will be same as returned.
Returned.
Well, let them produce that. Let me see it. Let me see it. They never send it. They never send it because your lordship kindly see, if it is correct, then your lordship kindly come to these 2 documents. Page 18 of the writ petition. Page 19. Your lordship kindly see, address or addressee of the applicant 23A Bijoy Bose Road, Kolkata 25. This is the address. Then your lordship kindly come to next page, page 20. 23A Bijoy Bose Road, Kolkata 25. Now, in this case, for issuance of the eviction notice, what they have written? Your lordship kindly come, page 8, page 9 of the report. Break Chetla station yard. Matlab Chetla station yard, there are huge property of the, and each plot having no plot number, nothing, no specification, only Chetla station yard.
Come back in 5 minutes.
Now, my lord, what they have written in the order sheet, insufficient address. Postal receipts and postal acknowledgement are not annexed here. So it cannot be proved that they have really sent the same or not, or they have wrongly submitted before the estate officer or not, with the documents or not. I was the impression they will produce the document. But nothing has been produced. Then your lordship kindly see. Your lordship kindly see this. They say that they have made an insertion in the newspaper. This is the insertion in the newspaper, 22nd November 2011.
Yes, 2021.
Yes. Now, this is the insertion. This is the insertion in the Times of India. Times of India. Maybe Times of India, but it is not Bengali newspaper, which is more circulation in the area. Times of India is very limited to the person. So far, my calculation is this. Whereas Anandabazar and Bartaman and other newspapers having circulation of 7 lakhs, 8 lakhs, 10 lakhs, this is hardly 1 lakh or 2 lakh. And normally it is usually given in two newspapers, one in Bengali, one in, and for that also appropriate order is to be passed by the estate officer as per the civil procedure code. Nothing. Straight away he passed the order. That order is also defective. Your lordship, can you see? That order is why it is defective. That has been indicated. No, here the one order has been passed. Yes, I'm sorry. Page 22.
Yes, same order at the bottom.
Yes.
It is
Yes.
to be put on the website as well as.
Yes. Now your lordship, can you see here the notice? Now your lordship, can you see section 4 notice? It is only in respect of yes. Your lordship, can you see that grounds that you have violated the fundamental condition for grant of monthly lease in respect of public premises by Shamaprasad Mukherjee Port, that you have default in making payment of monthly charges, that you have obstructed the representative. No question of obstructing of SMPK to make the inspection of the subject premises in clear violation of the terms and conditions of the lease in question. No definite particulars when they have gone and when I have obstructed. That you have failed and neglected to hand over the possession dated 13/5/1992 as served upon you by SMPK. It has never been served. Entire, your lordship, can you see, entire foundation of the proceedings is based on surmise and conjecture. Because the notice was never served on me, it was served on somebody else. They alleged, they claimed that even assuming the notice has been served on my brother, very well, all right. They say that the section 4 notice, show cause notice, has been sent to me through postal process and showing insufficient address, and insufficient address is written by them, not by me. It's their duty. And if it is written insufficient address, it is their duty to give the proper address and send it again. But if it is correct, my all addresses are insufficient, then I ought not to have been received the caveat. I ought not to have been received this notice for payment. And also, your lordship, now your lordship, is a very interesting thing. After the property has been taken, your lordship, can see they have no, your lordship, in affidavit in reply, I have enclosed one bill. Now, your lordship, kindly see, very interesting thing. This is page 12 of my affidavit in reply. Demand to Pankaj Chakraborty. Right hand side.
Yes.
Address 23A Vijay Bose Road. Period is 1/7/2025 to 31/7/2025. Eviction has been effected on 2nd July. July. Again, further notice. This is the further notice. Further demand. Can they produce that before issuance of 13/5/1992, they have issued this demand? After that, they have issued any demand? But if any person thought it that I am in unauthorized occupation, has not been paid the legal dues, they have to allege, they have to come with concrete evidence that demand has been raised, I did not pay. Without producing any document, anything, how they can say I am in unauthorized occupation?
Yes, sir.
Now I'll do another thing. Now after that, we have till that we have paid, and this is the order.
This order I have gone through. Your
Yes.
case is you
Yes.
have been
Now-
served
now-
with this order without following principles of natural justice.
That's
That is the
just
main case.
that's there. And well, there is one judgment on the self-same issue. Self-same issue. That judgment has been of the Calcutta High Court. It is of 2016 SCC online. Copy দাও। বলছি আমি কপি নিয়ে এসেছি, কপি দিয়ে দিচ্ছি, দাঁড়াও এক মিনিট। Yes. Yes. এ নাও ভাই তোমার কপি। My lord, this is relating to port trust matter of division bench judgment. My lord. Now, my lord, your lordship kindly come to other facts. I am not going into that. Yes. Your lordship kindly come to straightway paragraph 17. Learned Senior Counsel Mr. S.N. Mukherjee takes us to section 5(2) of the Act, contended that a date has to be mentioned in terms of section 5(2) of the Act, and section 5(1) reads as under. But I'm skipping over the same. Only thing here, the only catching point is this: after considering the cost, if any person in pursuance of the notice under section 4 and any evidence produced by in support of him, and after personal hearing, here the notice has not been served, question of personal hearing does not arise at all. If any given under clause B of subsection 2, the estate officer is satisfied that public premises is in unauthorized occupation, the estate officer may make an order of eviction for the reasons to be recorded therein, directing that public should be vacated. Here, that order of vacation has been made, but without having the satisfaction, without hearing me. Now, your lordship kindly see, relating to service through process server. Yes, your lordship kindly come to paragraph 18, next page, rule 24. Last paragraph 18, last line, he also refers to rule 24 of order 21 of CPC, which reads as under process of execution. When the preliminary measures, if any, required by the foregoing, unless have been taken, the court shall, unless it sees cause to the contrary, issue the process for the execution of the decree. Every such process shall bear the day on which it is issued, and shall be signed by the judge on such officer as the court may appoint in this behalf, and shall be sealed with the seal of the court and delivered to the proper officer to be executed. In every such process, a day shall be specified on or before which it shall be executed, and a day shall also be specified on or before which it shall be returned to the court, but no process shall be deemed to be void if on the day for return of the specified therein. Nothing has been done. And here is the case. If nothing, according to learned senior counsel, in absence of the port trust established in compliance of the above procedure, they ought not to have been taken possession of the property. Therefore, if the procedure contemplated for eviction of the unauthorized occupants is not properly complied with, the action of the authorized authorities in taking possession of the property, ignoring all procedure, per se illegal. And that has been upheld by the Honorable Court. But here also the same situation arose. The possession has been taken. There the Honorable Court has come to a solution as to how petitioner to be given possession back. And the way it has been solved by the Honorable Division Bench, I am ready and agreeable to do so. Because whatever their amount is claimed, let them issue a proper bill to me. I shall pay 50% at the first instance, leaving aside my 5,50,000, whatever I have paid. From that, now till tomorrow, till today, whatever is due and payable, because till today they have not taken they have put it lock and padlock there, but it has not been taken, or the auction, nothing has been done. It is as it is, status quo as on today is maintained as on 4th July. Even assuming that it is in my possession from 4th July to till today, whatever their amount is chargeable, due and payable, because they are only concerned about the money. Because they say that I am defaulting payment. Very well. I am accepting I am defaulting payment. Because bill was never served on me. So question, how can I pay it? Unless the service is given to me, I cannot pay it. Now, they are in the bill, they have given the outstanding demand is 9,12,127. Let them specify the same. Because out of that 9 lakh, I have paid 5,50,000.
Yes, sir. Let me hear.
Sir, wait a
Huh.
My lord, question of public premises eviction of unauthorized occupant act and the notice under the West Bengal Premises Tenancy Act are two different things. The first point that has been raised by my lord. There, my lord, in the West Bengal Premises Tenancy Act, the cause of action for the suit arose after service of the notice, which has been given under Section 6, giving the grounds within the periphery of the grounds that provided
No,
in Section
but we are not going into that at all.
My lord.
The question is not of cause of action. The question is whether he has been put on notice or not.
Yes,
The
he has
proceeding,
been.
it doesn't appear so.
My lord,
satisfy
I
that.
try to satisfy my lord. My lord, the question is that why I have spoken of the West Bengal premises and why I have compared these two acts is here, my lord, under the Public Premises Unauthorized Occupant Act. My lord, the question of giving notice by the Port Trust does not arise, or by any public. It is by the after filing of the application under Section 4, a show cause notice has to be
Very
issued.
well. So where is that service?
That service,
He
my
should
lord,
have due notice of the proceedings so
my
that
lord,
he can
my lord,
participate and claim.
my lord
He has
kindly
to-
comes to
he
the
has to
order
put his objection.
which have been affected. My lord kindly comes to the order. My lord, state officer.
Which order?
Yes, my lord. That has been annexed in my opposition. The two orders, order number 15 and 16. Let me place before my lord order number 15 and 16. My lord, order number 15, my lord. Order number 15 is, my lord, as my learned friend has shown, my lord, it starts at page 16. 16. It is submitted that OP come into the occupation of the port in question as a monthly
Yes,
lessee
I have
in
read-
default.
I have read
My lord,
this.
my lord. Now,
was
my lord,
placed.
my lord.
It was placed. I have read this.
Yes, my lord. In made out a then my lord kindly come to page 19. I am going
Please
to
answer. Please answer the points first, then go into
my
elaborate
lord.
judgments.
The
Please come to page 22.
my lord.
Page 22. You have said that a notice.
I have not stated it. The state officer has recorded it in his order.
A state officer is not God. He is your officer only.
My lord, state
Right.
officer
The
in
state
my
officer-
humble submission is not my officer, but a statutory authority
Yes, your
appointed
officer-
under the public
He is
premises.
your
are not.
officer only, whatever it is. He is your officer, is not a third party.
My lord, no, it is.
Very well. So the order is saying that notice was served through speed post and the same returned with the remark insufficient address.
Yes.
Now there are documents on record to show that at the same address notices were indeed served on the writ petitioner. Those documents are there.
Yes, my lord.
Where is the document which has been returned to you? The envelope which has come back to you with the
That, my
endorsement
lord,
insufficient
from
address?
the order itself, it is clear that it has been submitted before the court, and the
Where
court
is
thereafter.
that? Where is that? If you are filing an affidavit, that must be brought on record also to show that yes, you have indeed served,
It
and
is
this is
seen
not a
from
false
the
record.
records, my lord. Then I'll file. I'll come up with a supplementary.
Because
affidavit.
this has been challenged. They say that this is a wrong recording, and this indeed can be a wrong recording because he was not present.
My
That
lord,
is why I said he
choose not to be present. He choose.
That you can only say if you can show, if you can demonstrate that notice was attempted to be served, could not be served. If this is believed, if this is to be believed, then the other documents become without reason. The other documents have been served at the same premises at which this has been returned with the remark insufficient address.
My lord.
This belies logic.
My lord, or that, my lord, then I'll come up with a supplementary affidavit
So why
stating this way, because the order itself reflects, my lord.
This order is not a judicial order. There is a difference. There is a large, there is a big deal of difference between a judicial order proceeding
And
of
a
court recordings
quasi-judicial.
and
Quasi-judicial order.
quasi-judicial authority, more so when he is the officer of the same institution for which he is going to decide.
My lord, then, my
These
lord,
are
let
exceptions
me
to
file. That my lord has asked me to clarify this. Let me come up with the documents if it is available by your supplementary affidavit.
come up. Let him see if he can come with a
I have raised this specific point in my affidavit in reply, and the reply has been served on me long back. কবে সার্ভিস কিছু বার করতো ওটা? 1 minute, your lordship, can you give? সার্ভিসটা কোথায়? আগের দিন তো ছিল, তোমার কাছেই তো ছিল, তোমার বিষয়ের মধ্যে তুমি দেখালে তো আমাকে চিঠিটা। কি ফোন করছে সব?
So let me come up, my lord. This is a question. Verify
File
you
a
with, my lord.
supplementary affidavit within a week. I am fixing
My
it.
lord, 2 weeks, my lord.
2 weeks, fine.
My lord,
Next week.
kindly, my lord.
Well, it has been served on
I
him
humbly
in
beg, my lord,
the month of September.
Very well, Mr. Chatterjee. 2 weeks because it's matter of record.
Yes.
If he brings it.
and
Otherwise,
more record, my lord. My lord, let me come up with this within
Bring
2
it,
weeks.
bring
I'll
it,
try
bring
to
it.
bring this.
Mr. Chatterjee and senior advocate appearing for the petitioner. তার আগে লিখুন, this writ petition assails a proceeding under section. What is the section under which it is initiated? 7.
Thank you.
Under section 4 and under section 4 and 5 and 7. No, my lord, there I am facing only thing is this. One vacation I have crossed. Then your lordship kindly give
This
one.
will be a short vacation.
No, one status quo order to be maintained. Because if they try.
Because first, at the first instance,
No, at the
let us see what happens on fourth.
At the first instance, the Honorable Court was the impression the matter will be heard before the vacation. But unfortunately, the matter could not be heard because
Let us see.
the bench went to the Jalpaiguri. That's the reason. And after the vacation, it went to the again Andaman or anywhere, so it cannot be heard. That's the whole difficulty.
Very well. On fourth, let us see what happens.
Let us come on fourth. If necessary, I can give him earlier copy. He will give in 2 weeks. I shall give it because there are another 1 week is there from his time.
My lord, it's parts to 62 Act, my lord. Last occasion, His Lordship Honorable Justice Ajit Basu direct me to
I am
file.
for the state. Last occasion, this honorable court directs my learned friend to file a supplementary affidavit. My lord, I received the same today.
My lord,
The question regarding they have stated that regarding that. Let them speak.
my lord, only question last occasion, it is whether the property I have challenged, it is government land or not. My lord, I have annexed here a Moja map in the supplementary affidavit where clearly shows 1614 the land plot number
What is this supplementary affidavit for? Why was this required?
My lord,
In the petition, he has not described what is the property, what is his property.
no.
In this
I
context,
have
my lord,
described.
directed him to file one supplementary that to which Moja, what unauthorized construction, in which place it was unauthorized construction, that should be stated in by way of supplementary affidavit. And my lord,
In
that
the
was
writ petition, I have stated just in front of my land there is a government land, and there was a direction to file affidavit giving particular of the property. My lord, I have annexed here a Moja map where it shows the 1614 is a path and Paka Rasta. My lord, I have annexed here it. My lord, kindly consider for a moment my mark. My lord.
But who will take this decision as to whether it is
My
government
lord,
land or
my lord, SDO is the authority. SDO is the authority. My duty, according to my lord Act, Section 3, my duty to bring the attention of the government. That is a occupation of the government land.
So why is the SDO not deciding this?
My lord, my prayer is this.
Same matter. So far, I know, my lord, the same point. My lord, this is the dispute between the two, my lord, the relatives. My lord, there is a road.
One at a time, please.
My lord, there is a road between two houses. One is here and one is another is there. Now they are the co-sharers of that house, and between them a road is there. That is a village road. Now they said that he occupied the village road, government land, and that is regarding 161. Regarding same issue, one civil suit is pending before the court below. And my lord, on this occasion, one investigation is to be directed to be done. So far my knowledge goes, my lord, so far I have been informed, investigation is going to be directed to be done by the civil judge of that court to the authority. So inspection is to be required.
What is the civil suit?
My lord, civil suit in respect of.
But I have not
I'll
that
come back
document.
to
I
you.
have been
Please wait.
informed.
Please take your seat. Take your seat.
The actual suit has been filed by the officers of the civil court, and the civil court have satisfied the penalty of 1,200 order dated 22nd 2024.
Where is that order? Yes.
Yes. I kept the body. So number page.
Third page, madam.
Third page. Yes.
One page, madam.
on perusal.
I don't want to mention
Six from the bottom.
6 from the bottom of this particular paragraph. Whether the alleged O1 civil property land present beyond the boundary wall of the plaintiff, it is not yet.
Yes, sir.
My
This
lord,
issue is at large before the civil
my
court.
lord, it is absolutely different. My lord, I have filed.
You have seen the order.
No, my lord. My lord, kindly
You have
consider.
seen the order dated 22nd
My
of
lord,
April.
I have,
Please,
I have.
Please take the third page of the order. Please take the third page of the order. Third page of the order.
Oh, third page.
Third page. Now you please read the sentence beginning now.
Now, whether the alleged A strip Kopsian has land present beyond the boundary wall and the plaintiff where the defendant number 1 and trying to construct a Pakka road is, my lord, my
No,
condition.
thereafter.
My lord, I am coming.
Thereafter.
Or it is a part of the government land having 1614 cannot be decided at this stage without taking evidence. But
after
even
taking
if
evidence,
construct, my lord, that is my case where the government is trying to make a road on my land. What happened, my lord? There is a road between me and private respondent. My property is northern side of the road and their property is southern side of the road. They have encroached the government path, government road. And now what Panchayat is trying to construct a road encroaching my land. That's why I have filed a civil suit before the court. Now they have encroached the land. It's an admitted fact on the basis of the Act 62 Act. My lord,
so their encroachment is not the subject matter of the suit.
No, their encroachment is not subject matter of the suit. Subject matter is whether they are going to construct. They are going.
As I can understand, please correct me, all of you. As I can understand, please let me clarify. Then you make submissions. As I can understand from the facts, he has two contentions. One is that on his land, government is encroaching. It is for this purpose that the suit has been filed.
Yes.
And the other is that you have encroached government land. That is not the subject matter.
And
of this,
injunction, my lord, absolutely. Injunction has been granted in favor of me.
In your suit, where government is trying to encroach
my
upon your
lord, my lord, it is admitted fact they have encroached the land.
The plain. If he has any allegation against the government, so he has to make the government as a party.
Sir, that is why I said you should hear the court first, then your question will be, putting question to the court will be clearer. He has two allegations.
Yes.
In the play.
I have understood.
What you have understood?
Your lordship said whether he has filed two questions that he needs
He has
land.
filed one suit with the allegation that his land is being encroached upon by the government. This is one aspect that will be taken care of by the suit. Now he has approached the government in the form of the SDO, to whom he has made the application, saying that the private respondent has encroached upon government land, with which he has got nothing to do. So why will the SDO not consider this?
Malad, the similar issue since there is a question of civil suit regarding
again, sir, this is not there before the civil code. Maujas 1614 is not such a small mausa that it will comprise only the petitioner's
Yes,
land.
I understood.
In one mausa there can be
This
many
is a
lands.
road.
So very well. So he has approached the civil court with the allegation that the government has been encroaching upon his road, or sorry, his property, for the purpose of making a road.
That is not the your lordship.
Your lordship, my lord, let the SDO will decide whether
who are the parties in the suit.
My lord, SDO will decide whether government land has been
encroached. From the plaint, where have you made your government is not a party in your plaint?
My lord,
government is a party in your plaint.
Yes, my lord. Pradhan is the party and
so Gram Pradhan, right? Pradhan is encroaching upon the land.
My lord, Pradhan is trying to construct a road encroaching my land.
And Pradhan's
But mischief
contention-
maker is private respondent. He have constructed a building, two-story building on the road, just encroaching the road.
Two different stories are there. Why are you
Well,
not treating is a
completely different.
So far, my lord, I have gone.
My lord,
been instructed that this is
as
a
per the
suit
act,
pending.
SDO will decide
is not proper.
whether he has encroached or not.
Direct the video.
If they had,
You file a report how this instruction has been given to you. File a report clarifying that.
Well, so far regarding supplementary affidavit.
Let him file.
my lord, may I pray? My lord, may I pray one thing?
The respondent Give them some
Well,
time.
even then, they have not considered the matter.
You should have come then.
Well, after 15 days, no? Or
I don't know. I have disposed of.
now, my lord, what
Petition has been
my lord,
disposed of.
for my
We are
learning, I have,
observing that no mandatory order can be passed because this is
for my
preliminary.
learning, how much time?
At least a month.
At least.
When you file a civil suit, how many days notice do you give to the government under Section 80?
1 month.
How many days notice?
At least 1
notice
month.
is mandatory. Otherwise, civil suit is not
Yes.
maintainable. How can you maintain a writ petition for within 7 days of giving notice?
My lord, in that, my lord, this is also
Same thing,
similar.
7 days.
No,
Now, first I will have to see this.
One day.
The representation sent on 27th of October, filed on 28th.
लिखे दिन, same order.
I am making all that.
You have to give
honorable court.
that it has to be decided after 7 days. Show me that.
1 day. It is a 1 day.
I am not on that.
Then I am on that only.
Only what this judgment has held when an unauthorized construction has been carried out by any person. It is the duty of the authority concerned to remove the same on notice. Notice date is not there.
Well, there is a civil suit also pending. Well, I shall be filed. Can
When
allow me
have
to
you
file
made the
opposition.
representation?
27th of October.
Please wait. When have you made the representation?
কোনটা হচ্ছে? এই my lord 27 মারামারি করছে 28 এ
27th of October is sent. And
my lord দাও 20
Sir, you are there in this matter. Then
No,
why are you
no.
here? Why are you disturbing them?
আরে বাবা
27 is being shown.
Sorry, my lord.
আরে কেন এসব করছিস?
Sorry, my lord.
Please take your seat. Please take your seat.
আরে বাবা
Yes. Same order. Same order করে দিন. This we prematurely filed, so therefore no order is being passed. ওই same যেটা আগে বললাম. It is seen, লিখে নিন. It is seen that the writ petitioner has a
And 28th of October, it is filed.
What kind of writ petition are you filing, sir?
Just sent.
You file a representation on 22nd. In 4 days, you want them to decide.
I have sent my lord. This is true.
Why have you filed this writ?
This is true, my lord.
Why should you expect the authorities to act with such haste?
No.
And how can you can act in such a manner?
I cannot.
Then
my lord,
same order. No, sir, I will not.
Respondent number 3.
Same order. Whatever may be the respondent.
My lord, respondent number 3.
Sir, will you please keep quiet? Please wait. Take your seat.
Respondent number 3. Sorry, my lord.
This writ petition has been filed prematurely since the petitioner, prematurely, full stop. The petitioner has made a representation before the, there's 15 months. The respondent number very well. So you go there if they call you for notice.
I am applying for respond on 9/10.
File wakalatnama in the department. This affidavit of service. Affidavit of service filed today be kept with the record. Great.
Doctor, this matter has been assigned to me by an ailing advocate, and I have gone through the petition. Petition may need certain improvisation, but I will try today, Lordship.
Where's your other side? Lekin none appears for the respondents. Full stop. The very well. Lekin. You will be able to finish it in 5-6 minutes.
I would have prayed for time, so I have informed my learned friend yesterday. Kindly keep it after 20th. I had certain queries, they are
after 20th. लिखे नहीं? Mr. Rai is present.
Okay. Because some of the matters of the filing in the March, April, their number is like
Yes,
6, 7
they
to 4.
will get added.
If the 6 series comes, then the 20 series we automatically will go down.
Matters will be dealt with also, don't worry.
I'm grateful.
No, my lord. We have already, my lord, I have 40-50 matters have been taken.
Let us see. I am a little slow because first floor is a little lighter here.
Right.
So
And some matters, my lord.
My lord calls it lighter than we non-existent.
No.
19, my lord.
19 they will appear.
Appear, my lord.
Yes.
Because
যেগুলো 19 তে appear করার direction ছিল সেগুলো 19 তে যেন appear করে যায়.
I've enquired that file also came, my lord.
My lord will be
I'm
sitting on
grateful.
17th.
They'll appear on 19th.
Yes.
As directed, they'll appear.
My lord, sit on 17th. My lord is coming back.
Yes.
1 day.
I'll sit.
1 day training.
Yes. 1 day. One day means Saturday, Sunday. Both days. Sunday night we'll come back. Sunday midnight. It's hectic, very hectic, because we land at around somewhat near to 12. By the time we reach him, it will be time to come to court.
That's item number 13, minutes. I'm appearing, minutes, for the petitioner.
Number 13 appears.
Minutes, I'm appearing for the petitioner, my lords.
But I am appearing for we are appearing for the
None appears for the petitioner.
Minutes, I'm appearing, my lords.
Time, yes.
Minutes, I'm appearing for the petitioner, minutes.
21st or something he had prayed.
Minutes, I am appearing for the petitioner, minutes.
This Monday?
Yes, sir.
17?
My lord had kept.
It was 17 করে দিন এমনি. Not today.
Then 16, 17 and 18.
13 টাতে order হলো.
Minutes, item number 13, my lords, I'm appearing, my lords.
Not today করলেই তো সোমবার হয়ে যাবে. কালকে তো ওই অন্য গ্রুপ আছে. কালকে ওই অ্যাসাইন ম্যাটার গুলো আছে না, তো কালকে তো এমনিতেই হবে না. Not today করলেই not today. শুধু not today.
My lord will be sitting.
Minutes, item number 13, am I audible to my lords?
Maybe by 12:30 I'll be leaving.
Am I audible to my lords?
Yes, Mr. Goyal, you are audible for item 15.
Well, it's item number 13 also, my lords. I was appearing. I think I was not audible, my lords. My lords have given an adjournment, my lords.
Yes, because nobody was here. I thought nobody is appearing.
My lords, I was appearing online, my lords. I beg to appear online.
Carota Dinik. You'll be able to finish in 4 minutes.
My lords, if my lords wants, my lords.
I don't want. Let us see how we can proceed.
This is a small matter, although, my lords, the appellate authority has rejected the appeal on the grounds of delay, my lords. Although there is no specific application for the condonation, however, the petitioner did have mentioned the reason for delay being the lack of awareness and data retrieval, my lords. My lords, the period relates to
there.
My lords.
How many days delay?
Means there is 439 days delay, my lords. I'll come to the
39
point,
days
my
is
lords.
a bit too
Yes,
much.
there's this one factual scenario, my lords. It's one of a kind case, my lords. When I was also
39 days
dealing
is
with
more than 1 year. Now that
my lords, there is, my lords, this is the early stage, my lords, and in fact, my lords, I will put it on record, my lords. Both the petitioners and respondents, I will show by way, there are two appeals that they have filed, my lords. Appellate authority they have filed. Appellate authority rejected the appeal.
Where is the explanation, Mr. Goel? Where is the explanation? Where is the explanation for delay?
Malas, while filing the appeal, malas, they have mentioned the reason. They have not
Where? I
filed.
am asking you where it is. Where is the
Malas,
petition?
malas.
This online appearance is very difficult.
I had actually filed 2 appeals. If my first appeal order is at page 52.
Yes.
Malas, may kindly come to page number 50, my lords.
50.
50, my lords.
Yes, 50.
And in the last column, my lords, the reasons for delay, my lords, is mentioned due to lack of awareness and of process, my lords. My lords, it was a very early stage, my lords. 2017-18 is a period, my lords, which is involved. My lords, the petitioner has filed an appeal. The appellate authority has rejected the appeal on the grounds of delay, my lords. Then thereafter, my lords, surprisingly, the GST portal also allows the filing of an appeal. They have filed again, and they have given the show cause notice. The show cause notice also have attached. Whereas they have again rejected the appeal. The appellate authority has rejected 2 times, my lords.
No, but how
Whereas-
could the appeal be filed twice? If it has been rejected once, it has
Whereas
been.
I totally my humble submissions are, my lords.
Second rejection is of no consequence. So far as the first rejection is concerned, your grounds do not appeal.
Whereas I humbly pray, my lords, this is on merits, my lords. It's we have a very strong case, my lords, because the only supplier that they are talking about, my lords.
Delay difficult, very difficult.
My lords, I beg to submit, my lords. This particular aspect, my lords. Since there was lack of awareness, my lords, and my lords, there are several.
Then everybody will come with lack of awareness. If I
My lords, may kindly
lack of
impose cost, my
awareness,
lords.
I
Very
con-
small trader, my lords, 5 lakh, 4,28,000 and not the amount is, my lords. My lords, kindly consider this particular thing, my lords.
come physically for that. Let us see.
My lords, I will, my lords. I will, my lords.
Hard learned advocates appearing for the respective parties. এটা ওই 13-তে নানা পিএস যেটা হয়েছিল। List this matter for further consideration on November 24, 2025. Difficult. 400 days.
Because I understand, my lords, this is a lack of awareness, my lords.
Lack of awareness is again no ground.
My lords,
Lack of awareness is ground for condonation. Everybody, then if I allow 400 days for lack of awareness, why not 2-3 years for lack of awareness? I was unaware for 6
Let
years.
me also
Now I
consider
want
the petitioner is a proprietorship concern, my lords.
বাকি তো এমনিতেই নট টুডে হয়ে যাবে, এত নট টুডে বলার তো দরকারই নেই, বিকজ সেকেন্ড হাফ তো অরিজিনাল সাইড।
Before your lordship, may I mention some contempt matters has been filed before your lordship, some urgency in the contempt is there.
Contempt, what urgency, Mr. You want to nail somebody, there is urgency.
No, urgency is that your lordship direction to comply the auto pullers, they are not able to plying the autos. Your lordship direction also.
Contempt গুলো দিয়ে দেবেন একদিন। Give your slips.
My lord, regarding the assignment, my item is 295.
Yes.
But the text message is the next date given as 15th/11. How?
That I don't know. It's there in the list, though. It will be called on. I have not sent the text. Don't worry. I have not sent you. I have not SMS'd you.
No. Your officer, perhaps your officer.
Officers also don't SMS. Those are all automatic.
What the 15?
Sir, your matter is there in the list?
Huh?
Your matter is there in the list though.
List.
So don't worry, it will be called.
Okay.
My lord, I think 51 of these states, my lord. In this matter, my lord, there was an application filed for amendment, my lord. Leave was granted by Honorable Justice Rajashri Bharat, my lord, that the amendment be carried out. The amendment was regarding petition which was booked, it has to be mandatory. The entire amendment was done in the court, my lord, but it has not been yet acted upon. Please be granted so that the amendment be carried out, my lord, because in front of the court,
But amendment, I think original side is to be carried out by the department.
that time when what happened was that they told us that
Without an application for amendment,
yes, ma'am, the application was made, my lord.
application for amendment, that has been allowed.
Yes,
And it has to be carried out by the department. Amendment.
ma'am.
তো এখন তো করে দিয়েছে করে
I'm deeply obliged.
My lord, today morning also I've mentioned one matter which has to be filed before this bench. My lord, that has been filed. The similar matter, my lord, the batch matter for two financials. My lord, the leave need to be given. My lord, the lady officer was there. I'll just inform him if he can. She was. My lord, my lord, this matter need to be moved tomorrow because my lord, if the order has I understand, my lord. I understand, but if the petitioner over here is traveling from BR and he's already here, my lord, affirmation won't be taken place until unless the leave of the court is there. That is the difficulty I'm facing. Then he needs to stay back today. That is the only difficulty. My lord, I can She was there just 2 minutes ago. She was there. Otherwise, my lord, kindly instruct him. I'll just find her. I understand, my lord. I'll just call her from the department. Okay, much obliged, my lord.
Mr. Matter, what happened in item number 1? One of them also says that the order part by that is also an order of the I mean,
Yes, sir. Yes.
That has not been allowed for some reason.
Yes, ma'am. Milad.
Milad, my only grievance over here, I understand, Milad, I'm bound by the strictures of law. My only grievance is over here, the demand. I'm not going to, Milad, waste the coach time again reassessing the facts. Milad, I'm just stating very briefly. I understand. Milad, over here, the demand of duty was 97 lakhs. The penalty, personal penalty levied on the foreign exporter, Milads, is a sum of 23 crores. Now, Milads, in these circumstances, asking this honorable court to decide on merits going into it's very troublesome. It's not correct, Milads. But I request that a little bit leeway is given on the pre-deposit, and I do not say it's not unprecedented, Milads. I will show two judgments, two orders, Milads. One is of Delhi High Court, and one is of our own court, single bench, Milads, where circumstances have given a rise to a situation where the honorable court, rather than going to a question of law and the strictures of that, has gone into what has happened, and due to the high quantum of penalty, they have referred the matter to the honorable tribunal by reducing the quantum of pre-deposit. I'll just show two instances, Milad. First, Milad, I'll show the decision of the honorable Delhi High Court. Milad, I'll just briefly state what are the facts over here. Over here, Milad, there was an importer. He was importing truly areca nuts. The facts are given in paragraph 4 and 5, Milad. Over here, Milad, the importer was importing areca nuts. But at the time of filing bill of entry, the custom house agent, along with the importer, incorrectly treated as ammonium sulfate and imported the goods. They were caught by the customs department. Demand of duty and penalty on the importer was 2 crores, and the penalty, personal penalty on the custom house agent was a sum of 5 crores, Milads. The custom house agent, who is the petitioner in this case, Milads, approached the honorable writ court. Milads, the writ court went into whether he was part of this entire misclassification of goods and came to a conclusion, yes, he had a role to play because he was the custom house agent. But Milads, I draw your attention to the last page, paragraph 18 and 19 and 20, Milads. If your lordship permits, I'll quote the relevant paragraph. Milad. Paragraph 18, I quote, the petitioner is well aware of the CHA and the importer. The impugned order is an appealable order. The question as to what role was played by the petitioner would have to be adjudicated in an appeal on the basis of facts, as the same would not merely be a legal issue. However, the only question that the court considers at this stage is in respect of penalty which has been imposed upon the petitioner. The penalty appears to be slightly disproportionate considering the penalty imposed of rupees 2 crores on the importer. In view thereof, the petitioner is permitted to file an appeal challenging the impugned order before the Custom Excise and Service Tax Appellate Tribunal, along with pre-deposit of 7.5% of 2 crores. If, however, the penalty of rupees 5 crores is upheld in appeal, then the pre-deposit amount in full would have to be deposited by the petitioner. The petitioner is disposed by the above terms. Now, Milads, this is an instance where the court has seen that they are imposing personal penalty and penalty. Penalty in case of the importer who's actually committed the wrong. Over there, they imposed penalty of 2 crores as stated. But on the personal penalty, who's the custom house agent, they've imposed 5 crores. The court made a minor observation that it is disproportionate. In my case, Milads, penalty is 97 lakhs on the importer. It's 23 crores on me. Yes, Milads, I am. Yes, Milads. Yes, Milads. Yes, Milads. I understand, Milads, the trouble. Yes. Yes, Milads. Yes, Milads. Milads, if I may, there's one small fact, I think, which it appears to be a variable, is that, Milads, on the last occasion, I had showed that the cause in my case had arisen before the amendment under section 129 double E of the customer. Yes. Milad, let that question be placed before the honorable tribunal. They went on the Milad, it may be a question of law put because Milad, they will have to read and interpret the provision. If they read and interpret it to be saying that it is applicable, then I may be bound by it. And if they appear to saying that it's not applicable, because Milad, honestly speaking, there are two sides to this coin. There are judgments, as on the last occasion, Milad, I had shown in my favor. There are judgments which are against me also. There's Delhi High Court, Allahabad High Court. There is. But Milad, it is a question of law. Yes, Milad, I'll just show. Milaj, this lordship's your lordship's observations assured this in this Allahabad High Court judgment, Milaj. Same logic, same principle, Milaj. My only, Milaj, I'm just again the fighting chance, Milaj, I'm making is that it is a question that yes, it is. If it's 60% also in favor of yes and 40 also in favor of no or any other ratio therein, Milaj, let this one. Because Milaj, prior to the this is the problem. Because Milaj, why I say this is because Milaj, pre-deposit, it is not that there was no concept of stay prior to pre-deposit. There was a concept. The concept was that I had to file a stay application. So it was a regime which governed my. So.
like imitation. Uh,
Milad, my point is, Milad, I understand, Milad, but I am left at a very dark place, Milad. Hmm. Much, much, much.
Well, I can answer to his query if Milord wants to answer. Well, first of all, considering Milord has already considered the entire thing, so I don't. Milord, the order says that he has not deposited the pre-deposit in spite of ample time that is there, and we are not standing in the way. Yes. Yes. So on the question of judicial precedents, you kindly consider page 237 of volume 2 of their stay petition. This point which he is raising on the lump sum penalty has been agreed. Yes, that's what I believe. So it has been, it is now, as per it is an attempt by the petitioner to reopen the cause again and again. So with respect to my humble submission is, first of all, this read would not be mentionable. And the Milord's observation, I'm not standing in the way Milord is extending the time. I'm not on that. Milord, on the Milord. But if he wants it to be heard, then I have to answer. Otherwise, I'm not standing without protocol. Then Milord is admitting this reach and then
Milad, Monday. Much pleasure.
No. Milord, both of the matters are simple matters.
Serial number 1 and 2. Yes, certain. Much obliged.
And he can also avail this opportunity without disclosing this. He can avail an opportunity from Milord. I don't know why. I really don't understand.
Much.
Item number 3.
Your Lordship, and for the petition. This writ petition has been filed with twofold prayer I am making. An assessment order has been passed in the case of this petitioner, and thereafter I have filed an appeal. And in the course of appeal, I have also made compliance. My Lord, there is a CBDT official memorandum which has been issued, which states that during the pendency of my appeal, the department can take up to 20% of my outstanding demand. My Lord, what has happened? They have adjusted my refunds for the other years, and they have collected up to 60% of my demand. And further, my appeal,
during pendency of the appeal.
During the pendency of the appeal, my appeal is pending for the last 3.5 years, my Lord, and I have duly made my compliance. That appeal, and I have made my compliance. The appeal was filed in the year 2021, my Lord. I have made my compliance in the year 2023. And
isn't there a provision for obtaining stay of the recovery proceedings?
My Lord, I have filed my stay also. That stay was not disposed. to my knowledge, no, I have not received any order, my lord, and they have recovered my 60% of my demand. My lords, I am.
Why?
What is the first an application has to be filed before the assessing office, not before the there he has to pay for stay and deposit 20% amount. That 20% has been provided in the instructions.
My lord, my stay is there. Stay petition was filed. It is at page 38 of the writ petition, my lord.
I am afraid to say that my other friend's submission is matching, not matching with the.
My lord, my stay was there. And after that, I have also made my compliance before the CIT appeal. Kindly come to page 38, my lord.
Yes.
My lord, I have enclosed this. I have enclosed my appeal file, and I have prayed for keeping the demand in abeyance, my lord. And my lord, I have also made online compliance. This letter was filed online, which is at page 39, my lord. My lord, after that, on the immediately next page, my lord, page 40. This is my compliance made before CIT appeal, my lord. 14th March 2023, my lord. I made compliance before CIT appeal, and there is no movement of the case after that, my lord. And in fact, before AO, again in the year 2025, my lord, I have furnished a letter, a demand justice letter, my lord, page 62. Page 62, my lord. My lord, I am reading it out. My lord, I am writing in connection with the demand of rupees 9 crore 90 lakh raised under 156. In my case of the above mentioned assessment year 143 read with 144B. I have duly filed an appeal against the assessment order before the CIT appeal on 3rd of
Where is the CBDT memorandum? That
my lord, this is enclosed hereafter, my lord. Page 64, my lord. There are two official memorandums, my lord. First memorandum.
Which paragraph? 64?
Paragraph, my lord. Para 4, my lord. 4A. In order to streamline the process of grant of stay and standardize the quantum of lump sum payment required to be made by the SSC as a precondition for stay of demand disputed before CIT appeal, the following modified guidelines are being issued in partial modification of instruction number 1914. In a case where outstanding demand is disputed before CIT appeal, the assessing officer shall grant stay of demand till disposal of first appeal on payment of 15%. My lord, this 15% was subsequently revised to 20%.
But this is on your payment. You have not made any payment.
My lord, I have made the payment, my lord.
Where?
My lord, this is reflected in my letter. If you can see, my lord, this is the total payment.
Page?
Page 62, my lord.
Page 62. No, this is their recovery. You have not made any payment on your own.
My lord, they have recovered. I have to take instruction. My instruction that we have made a payment of 20%.
No, but the letter shows that they have recovered because you have not made any payment, so there is no stay. If you had made the payment, then there would have been a stay. They would not have proceeded.
Lord, even if I have not made any payment, they are entitled to recover only till the extent.
Where is that provision? That provision is
my
not
lord,
there. Recovery will continue.
My lord, I will show
There are two different.
My lord, I will show. I will show my lords the judgment of this honorable court. My lord, I have given a compilation, my lord. Just now. The first judgment, my lord, kindly come to page number 2, my lord.
Page 2.
Considering the facts and circumstances of the case, my lord. Consider the facts and circumstances of the case as appears from record annexed to the petition, undisputed and admitted fact which emerges. The admittedly petitioner is entitled for refund in respect to assessment years 10, 11 and 17, 18. Admittedly, statutory appeals before the CIT appeals are pending against the assessment orders relating to 11, 12, 12, 13, 13, 14, out of which demand has arisen, and for recovery of the same by way of adjustment has been made for refund relating to assessment year 10, 11, 17, 18. Admittedly, the amount recovered by way of adjustment from the admitted refund in respect of assessment year 10, 11 and 17, 18 for the demand relating to 11, 12, 12, 13 and 13, 14 are in excess of 20% of the demand. The legal issue which the petitioner has raised in this
Yes, Mr. Sharma, this is directly covering it. This issue is directly covered.
I have to look for some.
This is our High Court judgment. Very recent. What, you want time?
Sometime I can.
Let him come back.
Even I have asked for instruction from the assistant.
Because if this is the view based on a prior view of the High Court, they should not have even proceeded to recover more than 20%. All right, his name will be there. Naam to record kore, Mr. Aryak Dutt. Affidavit of service filed today. We kept it. Covered it. It appears to be covered.
Well, I am given to understand the copy of the writ petition. There's a shortcoming in the service. We'll complete that.
It has been served, mostly illegible, and there's no hard copy. So if you can hand over the hard copy.
Well,
it will
I'll
be
submit
easier
it
for me.
end of the day or tomorrow morning. Well, I'll ensure I'll send.
Then my lord, next step on Tuesday.
Yes, Tuesday kore.
Much.
I'm not passing any order.
Item number 5.
And for the petition. Your Lordship, there's a very short point involved in this matter, Your Lordship. Your Lordship, the petitioner had preferred an appeal from the adjudication order, Your Lordship. Your Lordship, the memorandum of appeal is at page 114. Thereafter, Your Lordship, the department was silent. We did not receive any hearing notice. We did not receive any order. When we inquired, Your Lordship, we were informed by a letter, Your Lordship, which is at page 174, Your Lordship. At page 174, Your Lordship.
You
That, Your Lordship. Your Lordship, I'm just placing this letter at page 174, volume 2, Your Lordship.
yes, yes.
Your Lordship, this letter is dated 12th August 2025. Your Lordship, in response to my inquiry, Your Lordship, they inform us. Your Lordship, I'm placing the second paragraph. It is informed that the said appeal has been adjudicated and order in appeal number so and so dated 17 March 2025 has been issued on 21st March 2025. However, the courier service engaged for delivery of this order in appeal, it should be had returned the consignment to this office on 26th March 2025 with remarks no such company at this address. So, Your Lordship, on 12th August, they informed me that an order was passed on 17th March. Thereafter, Your Lordship, on the very next day, I receive a recovery notice, Your Lordship, where they are saying that, which is at page 186, where they are saying, Your Lordship, that they will proceed to recover if I have not preferred an appeal. Your Lordship, the date of the recovery notice is 13th August 2025, Your Lordship. At page 1, Your Lordship has got it, Your Lordship.
Yes.
Yes. And Your Lordship, now, Your Lordship, coming to the order, which was served by the letter dated 12th August. Your Lordship, the order is P9, Your Lordship.
Page?
Page 175. P9, Your Lordship.
Yes.
Your Lordship, this order, Your Lordship, straight away, if Your Lordship comes to page 183, Your Lordship, at the top, Your Lordship, for the sake of natural justice, personal hearing in the matter was granted to the appellant as well as respondent on 17 December, 27 December, and 20th January. Neither the appellant nor the respondent or any representative on behalf of the respondent appeared. So, Your Lordship, none of the parties appeared. It is my contention that I never received any notice. Your Lordship, before this appeal, there was a pre-show cause to which pre-show cause notice was served on me. I replied to that.
That you received?
That I had received. Then, Your Lordship, I received a show cause notice. I replied to the show cause notice. I appeared for hearing. I submitted written submission at the time of hearing. I have always been diligent, Your Lordship. I have never missed.
No, but why does it record then that you were not present for
Your
hearing?
Lordship, none of them, Your Lordship, it is very strange, Your Lordship, that neither the appellant was present nor the respondent was present.
No, but you said you appeared for hearing.
Your Lordship, before the adjudicating authority, this is an
the
appellate
appellate
authority.
order.
Yes, Your Lordship. So, Your Lordship, here it is very strange that both parties did not appear on all three occasions. And Your Lordship, 3 dates are within 1 month. Then, Your Lordship, none have appeared. And Your Lordship, I have always.
Yes, Mr. Banerjee.
Well, the appellate authority is not a party.
Appellate authority is not required to be a party. Why should it?
Because the records, it is a separate, though it is under the customs department, but your lordship knows it is a separate entity, because it is the commissioner appeal which is deciding the appeal. Commissioner of Customs appeal which is deciding the appeal, and the records of proceedings are before it. The notices are whatsoever are sent to that office only. Well, kindly
Madam, add the commissioner appeal to the party.
Your Lordship, my understanding was also that we don't add him as a party.
Yes,
We made the principal
he's a
commissioner, Your
tribunal
Lordship.
in himself.
Lordship.
He is a tribunal in himself.
Yes, madam. But the records of proceedings are over there.
Your Lordship,
that you can also, you cannot get hold of those records.
If your lordship directs, then we will get all the file and produce it before your lordship.
Yes, you file. The file is not required. You file a report in the form of an affidavit how notices were served.
Lordship, may kind.
Because that is
the only thing to be
Your
done.
Lordship, I have a fully GST registered office, fully
That doesn't merit,
operational.
But
Yes, Your
let
Lordship.
them cross this hurdle
Your
first.
Lordship.
If this hurdle only is sufficient for them to.
Yes, Your Lordship. That's what I was submitting, that my office is fully functional with all government licenses. I have received all past notices. I have received by email, and I have always
Because
been
if
diligent.
they have been appearing all through, it is their appeal. They won't appear in their appeal.
Normally, the notices are sent by the office in respect of the registered address which is given in the appeal itself by speed post. No other modes are prescribed.
Your Lordship, here
So-
they've given the order by courier. and
So
the
whatever
courier was
is-
returned. And that is what is stated in that letter which
And
I
how
had
did you
received.
get this order?
Your Lordship, when I inquired, several months had passed. I inquired from the Your Lordship again. Your Lordship would take page 174. Inquired from
mail.
yes, Your Lordship. And next page, Your Lordship, they send me an
Don't
email.
they have any portal or something where you can get
Your
the
Lordship,
status of the appeal?
no, Your Lordship.
Oh, like
Not
the
like
state, you don't have a problem. Very well.
তুমি আছো?
But the challenge is not, the basic challenge is not to be noticed under section 148. But the normal cases, not the route of 148A is taken by the department, where they show cause, the reply. That the statute provides in certain situations that procedure need not be followed. In this case, that procedure was not followed because of the statutory provisions. And what I can just give the background facts. The petitioner is setting up these information technology parks. The entire infrastructure is set up. Some of these are in these special economic zones. And the income from that note is entitled deduction under section 80 IAB. None of the income which is received, these spaces are given to different institutions or entrepreneurs. And the amount they deduct tax at source, I return the income. I've been returning it consistently, under their business. I show it as profits and gains of business. I claim the deduction, and whichever gives the higher tax, that is the normal income or the book profit. I pay tax on that. There are not assessments in the past. There are at least 5 years where I have been the return with the income which I have shown under the head business has been accepted. Now, for this year also, I was in receipt of this income. Tax was deducted at source. Now, this it is entirely in my books. Now, I filed my return where this amount is reflected under the head business. The tax deducted source credit was claimed in the same return. Now, I received a query in respect of this return under 133(6), asking me, and they get the figure of the amount paid to me and the TDS from the annual information statement, which is also something I take into account in preparing my return and checking my accounts. So they say that this reflected in the annual information statement that you've received so much income and so much taxes being deducted, but have you reported this under the head house property? So I give a response. I point out that I have shown it under the head business, and there's also an element of interest refund received from the income tax department. So I mentioned that is also shown in my return, and they mention a lesser figure. I point out the correct higher figure. So I said, it is all there, and I say that this is how I have been filing my returns. Now that I give. Now they don't call me, and when the 148 notice has been issued, it says that I have failed to disclose this entire income in the books of account, with the income being 264.12 crore, which is reflected in my annual information statement, which is in my books of account, because I have shown it under the head business. Now they say, where did they see my books of account? But if they had cared to look at my return, because in the return, the balance sheet figures are filled up, the profit and loss figures are filled up, they would have seen that there are far higher receipts in the return itself. The tax the information which they take from the annual information statement, but that information is part of my return. If they even cared to look at my return, they couldn't have come up with this case at all. The dispute is regarding the head of assessment, but the case made out in the 148 notices as if the whole thing is suppressed. I'll take my note to the paper, I can demonstrate that from the record. But this is what has been done is the provision itself has been challenged because not if this is how the law enables them not to.
What is the provision?
That provision not is section 148 capital A.
Actually, I have a division bench at 3.
Not.
So I'll just hear you for a few minutes and then write because I'll have to go to the main building and please.
But section 148 capital A. Capital A note subsection 4. And that is the provision for not giving opportunity. So 4 says provision of this section shall not apply to income chargeable.
I don't have the new book. We have a copy. পুরনো বই আছে চেঞ্জ হয়ে গেছে নতুন করে আনতে হবে এটা 25-এর আনতে হবে চেঞ্জ হয়ে গেছে 2022-23 এরপরে অনেকগুলো অ্যামেন্ডমেন্ট হয়েছে 5 নম্বর কোটে থাকতে পারে বইতে রিকুয়েশন
shall not apply to income chargeable to tax escaping assessment for any assessment year. In the case of an assessee, where the assessing officer has received information under the scheme notified under section 135A. So this is the scheme of the e-verification scheme, and there's also reference to this note in section 148, subsection 3, clause IV. Where the word information is defined. So any information, clause for any information made available to the assessing officer under the scheme notified under section 135. By way of precedence, the provisions just before this, not except for the numbering,
the substance is the same.
Yes. So the earlier provisions were challenged before the Honorable Bombay High Court. But fortunately for the assessee in that case, the revenue came up in an affidavit agreeing that yes, they had made a mistake.
So the challenge was not decided.
But the court had put in caution that how the authority should proceed in a matter like this. Because to make an allegation that I am entirely outside my books notice really gone too far. And then I have to suffer this proceeding. But in the past, with the scrutiny assessment where they've accepted the head of assessment.
And what is your instruction, Mr. Dudhoria? Are you submitting as Bombay had submitted?
No, I need
then
to
we can do away with this.
I need to take some instruction more, but now, I need to take. Lordship will kindly give me some time, Lord. I'll take instruction.
Heard Mr. Khetan, learned senior advocate, appearing for the petitioner. Tomorrow it won't be taken up. Monday, all right, on Monday you ask somebody to be here and
that affidavit of service may be kept.
Affidavit of service may be kept with the record. On Monday, you please make this prayer. Thank you.